All right. Uh, Now, we just finished offer and acceptance online. Our next major theme is the retroactively updatable contract. We already saw this theme in our treatment of offline contracting with updatable contracts, and it plays a major, major role online, the retroactively updatable contract. Let me get our PowerPoint slides up and we will begin. So, the retroactivity is the new theme in online updatable contracts, and we'll get to that. Let's take a look at the current practice with retroactively updatable contracts. This is from the New York Times Online. They have a particularly well-written terms of use agreement, which is the reason I use them. And note that after the first paragraph, which is about who the parties are, you're using the New York Times and so on, that's paragraph 1. This is paragraph 1.2. They reserve the right to add or remove portions of these terms of service at any time, which shall become effective immediately upon posting. And and we will get to, as we continue our discussion of retroactively on updatable online contracts, we'll get to why it includes these other two conditions as well. But for right now, what we want is this, right? This says we can update the contract. Oops, sorry, there. In any way we like. So this is the updatable, we can update it in any way we like. This is the remarkable claim, right? That you've entered into a contract with the New York Times, but the New York Times on its own, unilaterally, can change the terms of that agreement at any time. And if you continue to use the New York Times website, you agree to those changes. And as we'll see, they don't just mean that the changes take effect going forward. They mean we can change the terms of this contract, and then this becomes the contract that governs your relationship with the New York Times from the beginning when you first entered into a contractual relationship with the New York Times to now, right? The reason for that claim that it reaches back and governs your relationship with the New York Times from the beginning is to allow them to efficiently manage, collect, and process data, efficiently collect, analyze, and use data, because they want the same information processing routine, the same information processing process and mechanism for all its customers, no matter who they are, no matter when they signed up. So when they change the contract, they claim that it applies to all the data that they've ever collected about you. They don't have to have one information processing regime for the data the first 2 years of your relationship with the New York Times. Then they change the contract, so another one for the next 3 years and another one for the next change after that. They just want one contract governing all of the data collection that has ever occurred. So that's what they claim. Let's review the offline version. Right, we did Purdue versus Crocker National Bank. And so let's review. That was our offline updatable contract. We didn't worry about the retroactivity claim. It wasn't relevant. There was no claim. Okay, and these changes go back to the beginning of our relationship. The bank didn't need that, right? But online we do. So Purdue had a checking. We recall the facts. Purdue had a checking account with the bank for a number of years. The bank raised its charges on not sufficient fund checks over the years, right? Kept charging more for processing checks drawn on accounts that didn't have enough money in them to pay the check. And Purdue finally complains about that, his theory being, look, I entered into a contract with you years ago. At that time, the not sufficient fund charges for checks were whatever they were, X dollars, right? And he says, And so that our agreement, among other things, was that would be the charge. And since we agreed on that charge at the time I opened my account, you can't change it because we're both contractually bound that that is the charge, right? That was his claim. Right. That, and so that's his breach of contract claim, as we discussed when we discussed Purdue. Hey, I opened my account subject to certain terms and conditions, the fee for insufficient fund checks being one of those conditions. You can't change it on your own, right? Because the idea, well, look, that's the point of contracts. I commit, you commit, and neither one of us gets to change the conditions of the commitment on his or her own. And as we said, the court rejects that claim because they point out that the right to make changes was in the offer itself. The deal that Purdue had with his bank was banking services in exchange for Purdue's agreement to various terms and conditions. One of those terms and conditions being that Purdue gives the bank the right to make changes on its own, right? And that's what they point out. The court points out in the fact that Purdue agreed to, we just need this. Purdue agreed to present and future rules, right? So the court says, gee, hey, Purdue, you agreed to the conditions that currently obtain, and you agreed to future rules, and that's to agree that the bank can change those rules and you'll abide by them. That's what the court says. So it's an updatable contract and no problem, right? No problem because, right, when the bank makes changes, it's not creating a new contract, not creating a new offer to enter a new contract. It's exercising a right it has under the old contract. Same contract, just exercising a right under that contract. And why did they do that? Before, let's go take a look. Before we get into why, let's take a look, right? To remind ourselves, this is the same thing. The online terms of use agreement is the offer from the New York Times, and in that offer is the condition that the New York Times can make changes on its own to the contract. Same deal as Purdue versus Crocker National Bank. So why did the bank do it? So we have to, why did the bank do it, and why do they want to do it online? The answer is basically the same in both cases. Why does the bank do it? The bank's in a long-term relationship with its account holder. So given that there's a long-term relationship, things are going to change over the course of that relationship, and the bank will need to change its contract from time to time. It's going to have to change its fees as economic situations change, customer practice, banking practice change. There will be new government regulations it has to comply with, and it will need, information from accounts to do that. It has to get the permission to do that. And banking itself will change, right? It may need to change in response to new market competition. Cryptocurrencies are one example from today, as are new requirements on banks sending governments information to control money laundering, terrorist activity, tax evasion, and so on. Things change. So in a long-term relationship governed by a contract between a bank and its consumer account holder, they're going to have to change that contract to give the bank the ability to do what it needs to do as the times change. That's the reason for the contract. And what businesses don't want, the change avoids this problem, right? Imagine that the bank has the same problem, but let's illustrate the problem online, right? What businesses don't want. Same thing holds for businesses online. So suppose you start out with the New York Times here with one contract. Then, just like the bank, the New York Times needs to change its contract, say, to, because it has different government regulations to comply with. It has different opportunities for information processing, wants to use the data in different ways, wants to use different data, wants to have different conditions on the data, all of which happens online. Right, same thing as we noticed happened to the bank, responding to government regulations, change competition. And what the New York Times wants to do is to avoid this situation, right? So they don't, if they change their contract, you sign up here, and if the contract, they can't change the contract, right? You have one set of contracts. These people that sign up here, the people that sign up here have another set of contracts. The people that sign up here have another contract, right? The contracts, if they're not allowed to change the contract and make it retroactive, the contracts will just proliferate like crazy, a horribly inefficient, complicated situation. Neither the bank in its offline contract nor the New York Times in its online contract wants to be in this mess of having, 100,000, if the New York Times has, I don't know how many users, maybe 100,000, maybe a million, right? Having hundreds of thousands of different contracts governing, because they all were entered in at different times, and they can't change them all to govern everybody at once. That's what the New York Times wants to do, just have one contract for everybody, even though they make changes in it. Those changes sweep back and govern all the relationships with everybody from the beginning. That avoids this situation, right? That's very good business reason. So that's why they want to do it, right? And as the Purdue court notes, and as the courts online have noted, there have to be some limits in a retroactively updatable agreement. Otherwise, there's no agreement. And we discussed this when we were discussing Purdue, right? Yeah, you can give a party the right to make unilateral changes in a contract, but they can't have the right to change absolutely everything. Otherwise, there's no contract, right? A contract is a commitment from one party and a commitment from another party. And if one party can change any part of that commitment at all, then they're just really not committed and you have no contract, right? There has to be something. There have to be commitments that both parties can't change unilaterally if it's a contract at all. That's the point, right, of contracts. You commit, I commit. Neither of us can change those commitments on his or her own unless one side gives the other side a limited power to change those. If it gives it an unlimited power, then there's no commitment from the other side, right? So there must be some limit. That's the Purdue court's point. And the Purdue court says it mentions the good faith limit, right? This is what we noticed when we were discussing Purdue, where when one party has the discretionary power to change terms, there's a duty imposed on the party having the discretionary power, the bank in Purdue, the New York Times, in our New York Times example, to exercise that power in a manner consistent with the covenant of good faith and fair dealing, right? The covenant's the promise of good faith and fair dealing. And we noted in online relationships, let's put this in the slide. In consumer online and offline relationships, good faith is a matter of reasonable expectations. Right. Acting in a consumer context, acting in accord with good faith means respecting the consumer's reasonable expectations about contractual terms. So while the Purdue court uses the good faith language, which we pointed out before discussing good faith, it brings us back to the Stevens case about reasonable expectations. This is a requirement that I respect a consumer's reasonable expectations. So Purdue can't violate, the bank in Purdue can't violate Purdue's reasonable expectations about terms, and the New York Times can't violate your reasonable expectations about terms. That's a commitment that they can't change, that they have to keep. So that's the picture we get of updating online. And just to fill out our explanation of why online businesses want to do that, right? They notice that they're just like the bank, they have long-term relationships with consumers. And as I say, contracts play a key and unnoticed role in defining that relationship with consumers. Remarkably, in the commentary from law professors, privacy advocates, and so on, and even in the courts, not so much in the courts, but some, nobody has emphasized the key role contracting makes in the relationship with consumers and businesses. If we're talking about controlling the long-term relationship between a business and a consumer, right? A relationship that involves heavy collection and analysis of data, the contract plays an absolutely central role in defining that relationship. That's one reason we're talking, and the main reason we're talking about online contracting, is that it's a central role it plays. And why does it play that role in the form of a retroactively updatable contract? Because of the same situation as we illustrated with Purdue. A long-term relationship. And two things that are different from the bank, our relationships with businesses now are highly interactive. How many times a day do you go on Facebook or search Google, use Gmail, go to LinkedIn, Twitter, whatever websites, social media websites you're on? Quite a lot, right? If you're like most people. It's much more interactive even than the relationship between Purdue and his bank, right? These are highly interactive relationships, and they involve data collection, a data collection that occurs every time you go on the website, right? So this is the new thing about online transactions, and a new thing about online contracting, which governs this complex long-term relationship, right? And that differs from our relationships in offline contracting and with non-digital products. Right, as I said, when you buy a toaster, hair dryer, or whatever, how often do you interact with the manufacturer? Hardly at all, and probably never. But as I said, how often do you interact with Google, Amazon, or Facebook? More than daily, right? So, and just for the background, and just to underscore the point that intensive data analysis, collection data analysis, information processing lies in the background. Just to underscore the point, because why does it do it? Because that's how they make money. It's critical. I don't think in the lawyer world, at least in the US, at least in the law professor world, people appreciate enough the profound change in the way business is done that's occurred since like the 1980s, and with at an ever accelerated pace into the 21st century. Right, everybody collects and analyzes data. I just quoted from a book for undergraduates and graduates in business schools, noting as just taking for granted, look, the more data you have and analyze, the better your profits generally, right? That's why they do it. Amazon's a good example. Amazon just collects massive amounts of information. It's in a long-term, highly interactive relationship with its customers. It needs a lot of flexibility in that relationship, so it needs to update its terms of use a lot. But it's an excellent example of the modern business situation. And a nice example of updating is LinkedIn. Notice this example is from 2015. Why do I keep a 5-year-old example? Because websites are not quite as forthcoming about how much they changed their terms of use agreements and privacy policies now as they used to be. For good public relations reasons for them. But look at what LinkedIn does, right? So we're talking about retroactively updatable contracts that needs to be changed. And this LinkedIn example is an example of just how big the changes can be, right? LinkedIn at 2015 says, we didn't, they say the information we received through your address book will now include phone numbers. So the change in 2015 is we weren't collecting your phone numbers, now we are. We didn't let advertisers, before 2015, we didn't let advertisers identify you from information we collected about you from cookies and other technologies. So we didn't let the advertiser figure out that this person on LinkedIn that I'm sending an advertisement to is actually Sally. Right? We now let them do that. We now let the advertisers personally identify you. And then we use our information for research and development, which means they can just use information for anything they want to, as long as they label it research and development. These are really big changes. That's the point. Not only, right, will a business like Amazon needs to update its policy in terms of use agreements, but if you look at the kinds of changes they make some really big changes, right? So now we're going to look, we have a couple of cases about retroactively updatable contracts, but the point I wanted to emphasize in this video is there's been a big change in how contracts are used. They're now used for this retroactively updatable contract in the long-term relationship with the consumer to allow the business to collect and analyze data with enormous flexibility in a way that allows the business to enormous power to set the terms of that data collection. So what we want to look at now is the limit on that power, right? The limit of respecting a consumer's reasonable expectations. And there are 2 central cases about that, relatively recent cases about that online, that we'll look at in the next video. So that does it for this video. We will be back with the next.